Hey everybody, this is Steve Sizik. I am the of counsel tax attorney with the Harris Law Firm Tax Division, doing a webinar with respect to employment retention credits. This one's entitled "There's No Such Thing as a Free Lunch," which is a rather dubious but famous economic term. The rise and fall of IRS employment retention credits. The reason why I use that title is exactly how you would think it. Anything that sounds too good to be true, free government money. Usually it is. Sometimes you can actually take advantage of some of those government programs to your business's advantage, of course, but certainly we wouldn't want anybody to take advantage of them inappropriately. Obviously not fraudulently. And if you're doing something fraudulent, then certainly we're not going to be able to help you as much. But the idea of this webinar is to verify what can be done if you got one of those cold calls over the past couple of years about the $26,000 per employee. Just send us your 941s and we'll get you a big fat check. And maybe you didn't qualify, or maybe you don't know if you didn't qualify, or you're concerned that you didn't qualify. And what actions you can take to protect yourself and your business so that you don't have the big bad IRS showing up and really ruining yours and your business's day, which is going to be a theme here over the next couple of years, based upon some of the actions that the IRS are taking. So, with that, we'll move to the first part of our three-part series. This one is going to go through some initial agenda as far as what we're going to do. We're going to talk about what employment retention credits are. If you did try to claim some of these and you weren't really sure what you're getting yourself into, we'll give you some background on that. Who legitimately qualified for these credits? How ERC mills, as they were called, these are these big call centers, just trying to push, essentially marketing teams pushing cases through to just paper processing divisions without doing any sort of internal regulation or audit as to whether people actually qualify for these things. How they abuse the system, and the IRS obviously figured that out. What they've done to address that, and what they're doing to address that. And then, most importantly, in the third part of our series, will be what are the actions that you can take to not only prevent the audit if one is already, if you've already filed and you think one's coming down the road, but also how you can address an audit to your advantage if one does show up and the IRS is asking for their money back with penalties and interest, which is always super fun. So we'll get into the first part here about employment retention credits, what they are. It was just a CARES Act, COVID-based tax relief, similar to PPP, some of the SBA stuff. Everybody's fairly familiar with, that time period. If you owned a business during this time period, it certainly has created some PTSD. I had a firm of my own during this time period, and I remember it vividly. Did secure PPP for myself and my employees, and it was certainly approached with respect to whether an employment retention or credits would be something that my firm would need. They didn't know they were calling a tax attorney, and that I had already probably vetted that 1,000 times to see if it would have been a good avenue for myself. It was not. I did not qualify. And you'll find there's some reasons why I didn't. And I was still getting those calls, and I was still getting people, claiming to me that I didn't know what I was talking about as far as why I didn't qualify for, 26,000 for each of my employees. So understanding what we're dealing with, and what some guy told you on the phone, or some lady told you on the phone as far as qualifications, doesn't always equate to what is reality when it comes to IRS audit and negotiation. I found myself sort of rolling my eyes at these people that were calling me, telling me I was subject to, getting all this windfall from government programs. So the logistics for those is typically you get a amended 941. 941 is your withholding tax return, and that's what you file quarterly. And during the periods in question, if you did qualify for these credits, you could reduce your tax burden by filing amended returns, zeroing out portions of those taxes that you already paid, which would then be refunded to you as a credit or an overpayment on your taxes. The intended compensation or the intended consequences of this, or at least what the CARES Act drafters were trying to do, was to not only promote business growth and to sustain businesses through that COVID period, but also as an incentive for those employers who actually maintained employees in good faith, essentially trusting the government as opposed to laying off all of their employees and sending them into the fray, into the unemployment system. It was a incentivized sort of program to say, hey, if you maintained your employees and paid their payroll and their taxes, even if they weren't working at the time, we're going to go ahead and reimburse you for that. Which no good deed goes unpunished when it comes to government tax breaks, we've found. So it has been helpful for some. The specifics with respect to ERC, the applicable time frame, it's not still ongoing, regardless of what people might tell you. It was only during the first quarter of 2020 through the fourth quarter of 2021. So fairly limited, time frame. You do have a 3-year filing deadline. So a lot of those 2020 timeframes have expired. 2021 certainly coming up here this year. So if you are looking to still file for these, and after reviewing this, you feel like, hey, I actually do probably qualify, I can get some refunds here, you would be on the hook to get with a qualified person to review those options with you before the end of the year, specifically now, third and fourth quarter. And then you can move forward to file those. Whether you're going to get a response on those in anytime soon, probably not. But you might as well get them in the till if there is some money to be obtained and you qualify for it, which we'll go through as well. It was, it's up to 5K per employee for 2020. Like we said, most of those have expired at this point as far as whether you can claim them. And then it was up to 21,000 per employee for 21. So that's where the 26,000 per employee figures came from. There's actually some other more nuanced versions where you've got some different types of employment payment structures where you actually could qualify for up to, I think, 30 between the 2 years. But most people weren't claiming those because they were so limited in scope that it was just going to create issues in trying to pursue those. So 26,000 per if you had qualified for every employee for every potential period. That's something to note because it's not just 26,000 across the board. It had to apply to every single quarter per employee, that type of thing for the period of year. So it was up to those amounts. It didn't have to, just 26,000 across the board. And if you had somebody that was just plugging those numbers in as a flat figure, that would be one of the audit risks. These are adjusted by a couple different acts that came out, and the extension on timeframes as well. And that was the Consolidation Appropriation Act and the American Rescue Plan. So not a whole lot to do as far as the application of an audit with respect to those particular provisions, but it was fluid and it has been fluid, up until very recently, I think, with the IRS just recently coming out with some provisions as to how to apply some of these acts. Who actually qualified? So you had to be operational during the COVID-19 period. So you couldn't have just opened your business in 2022 and then get qualified for this type of thing. You had to have an active business. It could have been stagnant. Even if your business was shut down, was it active in that you had employees who weren't working, who were just kind of waiting in the wings? Were you still paying for your telephone bill and your electricity, and maybe you're paying for insurance and the rest? It doesn't take a whole lot to verify that you're active, just that you're not stagnant and that there was no operation at all during those periods. If your bank account showed that you had nothing going on, like literally nothing in or out, that is not active business, so you would not qualify. That's not a huge one to prove, but sometimes people who had dormant businesses were trying to claim ERC for themselves, and that can create problems if there was no actual operation in place. Number of employees, you got this small or large employer situation. Hey, it got expanded because of the adjustments to the acts. But in 2020, it was 100 employees or less. And then in 2020, it was 500 employees or less, partial or full-time. If you're deemed a large employer, and this gets a little bit sticky if you're a franchise and they're aggregating the employees. But if you're deemed a large employer, then only employees that would qualify were ones that were not working. So if you had a Chinese restaurant and you had employees that were doing fine, even they're running basically Uber Eats the entire time during COVID, probably doing better than you were before. You can't claim those employees that were actually working during the period for that ERC, even though you were in operation. If you had more than 100 employees during 2020 or 500 during 2021. And that's where the IRS can actually aggregate if you've got multiple stores and they're essentially managed by the same group. That's where we run into some problems where it's 5 different separate entities per se, but they're all under one management group. They've got 500 or more actual employees when they aggregate those numbers, and then that would disqualify for the ERC request. You have to have a drop in gross receipts or a governmental governmental affecting operation action. So the drop in gross receipts is pretty easy. CPA can look at essentially your receipts from a quarter in 2021 to equivalent quarter in 2019. And then the same goes for 2020 to equivalent 19. If you just started operation in 2021, then it would just mirror back to the previous year, back to 2020. So those are fairly straightforward, but once again, these ERC mills were not looking at these figures. So reverting back to my previous example regarding like the Chinese restaurant, those I guess establishments in a lot of cases, pizza restaurants, electricians, a lot of landscaping companies, people that were actually working more during COVID, even though they had some effects to their operation due to various different things that were going on, had a hard time proving that they made less. A lot of these delivery companies were making way more than they did previously. COVID was actually a boon for them, right? And so coming back and trying to prove that, yes, in this, in the second quarter of 2020, where they were, running deliveries 24/7 versus 2019, where maybe they had some in-store guests and maybe just a normal amount of deliveries, that can really throw that off. And so it's something that had to be looked at. And a lot of time these mills didn't even take a look at the books to see if they're qualified. And that's where there's a big OR that comes in there. The OR is the governmental action, order affecting action. Let's say it is a pizza restaurant and they're, delivering pizzas everywhere, and they don't necessarily qualify for the reduction of gross receipts. You can locate and identify actual written orders from the government, and that doesn't mean necessarily mean the federal government. That could be a local ordinance, that could be a state ordinance, that could be a city ordinance in some cases that would necessarily affect your income. It only has to be a little bit more than 10%. So we had these orders where it was like you could only eat on the sidewalk at this restaurant, and even if that restaurant is doing most of its production and its income from deliveries, its total revenue has been affected by more than 10% because it has this whole restaurant that it can't utilize to generate income. So if you can actually secure the written documented order that's in the area that the operation was taking place, and it is tied to the business, electrician can't say, well, I had to eat outside because of this order, so that affected my ability to go into this warehouse and work on this job. That's not going to work. It has to actually physically and substantially affect the operation of their business. We call those the big two. And there's some case studies with respect to the big two: drop in gross receipts or governmental order. These were the two major things that these ERC mills were not looking at. And these are the two major things that I've seen that the IRS is looking for as far as when they are going to do an audit on any particular company. So this is the first of the three webinar series. Next time we're going to go through the big two and specifically how those apply in a couple of case studies, some interesting ones that I've worked with. And we will then move into the audit out in part 3. So I look forward to seeing you in the next one. And until then, my name is Steve Cizik, once again, with the Harris Law Firm Tax Division. My contact is there at the screen, and feel free to reach out to me if you have any questions regarding this particular webinar.